which deals with the executive power of the president, is the case of Mondano versus Silvosa. Here, a rape and concubinage complaint was filed against petitioner, the mayor of Mainit, Surigao, with the Presidential Complaints and Action Committee. The petitioner was served a copy of the complaint. On the same day, the provincial governor issued an order for the suspension of the mayor, and the provincial board proceeded with hearing the complaint despite petitioner's objectives. Respondents, the provincial governor, and provincial board aver that department heads are clothed with direct control, direction, and supervision over all bureaus and offices under his jurisdiction, and to that end, may order the investigation of any act or conduct of any person in the service of any bureau or office under his department, and in connection therewith, may appoint a committee or designate an official or person who shall conduct such investigations. The issue in this case is whether or not the provincial governor has the power to suspend and investigate the actions of the mayor with regards to the complaint filed. It was ruled that the investigation and suspension were unlawful and without authority of law. The provincial governor or department heads do not have control over the local government units. Further, rape and concubinage, although involving moral turpitude, have nothing to do with the performance of his duties as mayor, nor do they constitute or involve neglect of duty, oppression, corruption, or any other form of maladministration of office. Even the provincial fiscal cannot file an information for rape without a sworn complaint of the offended party, who is in this case 28 years old, and the crime of concubinage cannot be prosecuted but upon sworn complaint of the offended spouse. The concept as discussed here is that the president has been vested with the power of control of all the executive departments, bureaus, or offices, but not of all local governments over which he has been granted only the power of general supervision, as may be provided by law. The department head as agent of the president has direct control and supervision over all bureaus and offices under his jurisdiction, but again, he does not have the same control of local governments as that exercised by him over bureaus and offices under his jurisdiction. Likewise, his authority to order the investigation of any act or conduct of any person in the service of any bureau or office under his department is confined to bureaus or offices under his jurisdiction and does not extend to local governments over which, as already stated, the president exercises only general supervision as may be provided by law. Another case is Marcos versus Manglapus. Here, the former President Ferdinand E. Marcos, in his deathbed, has signified his wish to return to the Philippines to die. But President Cory Aquino, considering the dire consequences to the nation of his return at a time when the stability of government is threatened from various directions and the economy is just beginning to rise and move forward, stood firmly on the decision to bar the return of Marcos and his family. The issue here is whether or not the president has the power under the Constitution to bar the former President Marcos and his family from returning to the country. In this case, it was ruled that the president, having sworn to defend and uphold the Constitution, is obligated to serve and protect the people, maintain peace and order, protect life, liberty, and property, and promote the general welfare. The power involved in the president's residual power to protect the general welfare of the people. It is founded on the duty of the president as steward of the people. The trial court found the existence of factual basis, or the court found the existence of factual basis in physical security and in economic stability for the president's decision. It was ruled that the president did not act with grave abuse of discretion. In this case, the concept discussed was that although the 1987 Constitution imposes limitations on the exercise of specific powers of the president, it maintains intact what is traditionally considered as within the scope of the executive power. Corollarily, the powers of the President cannot be said to be limited only to the specific powers enumerated in the Constitution. In other words, executive power is more than the sum of specific powers so enumerated. It has been advanced that whatever power inherent in the government that is neither legislative nor judicial has to be executive, and that it would be a folly to construe the powers of a branch of government to embrace only what are specifically mentioned in the Constitution.